Good afternoon, everyone. This is Anna Scholl with the Maryland State Bar Association. I welcome you to our Estate and Trust study group topic. Today we have Lindsay DeAndre and with Incomplete Gift Non-Grantor Trust, Everything You Need to Know. I will, in 1 second, turn this over to Richard Adams, who will do a more appropriate introduction of our speaker today. But I just want to go over a few logistics. First of all, we will be taking questions and populating that for our speaker. So if you have questions, you have two options. You can type them into the YouTube chat box, or you can email those questions to angela@msba.org, and her email address should be on your screens that you're watching now. I wanted to also take a moment and just thank Micah Snitzer and Richard Adams, the co-chairs of this study group, for helping to make sure this happens today. Even during COVID, we want to make sure that we're bringing you relevant information for your practices. The last thing that I'll ask you to do is to subscribe to our YouTube channel. We have been promoting a lot of our webinars, some of them COVID related, some of them just on general topics. So if you want to stay up to date, if you can take a moment to subscribe to our YouTube channel, that'd be great. Without further ado, I'll turn this over to Richard Adams.
Thank you, Anna. Good afternoon, everybody. Thank you for joining us today. Thank you, Lindsay, for agreeing to, basically handle this virtually. We appreciate that. And so I just want to kind of introduce Lindsay. She's a staff attorney at Baker Hostetler in Washington, D.C. And she works with high net worth individuals and families with estate administration and estate planning. She's notably collaborates with clients on fiduciary and estate planning matters, and also works on non-judicial settlement agreements. So without further ado, Lindsay, please take it away.
Thank you, Ricky, and good afternoon, everybody. As much as I wish that we were all in person, or that I was, reconnecting with friends and former colleagues in the Baltimore office, I'm pleased to be doing this today. Thank you to Micah and Ricky for ensuring that this presentation could happen today. And a special shout out to Anna Scholl, Bill Hall, and Angela Monroe for getting us this platform so that we can put this all together. I also want to make a couple of just acknowledgments before I get started here. One is that when I initially agreed to give this presentation in the fall, we didn't envision that we'd be dealing with COVID-19 right now. So I hope the takeaway today is not that incomplete gift non-grantor trusts are particularly relevant in this environment, but that it's something you keep in the back of your mind for when the dust kind of starts to settle. The second thing I want to note at the outset, and I'll circle back to this at the end of the presentation, is that for Maryland residents, incomplete gift non-grantor trusts would be a difficult thing. You wouldn't be able to achieve all the benefits with a Maryland resident. I'll talk about that a little bit more. But that doesn't mean that these are things we shouldn't be thinking about, especially because we live in a transient society. We have clients who move all over the place for various reasons. And so just because you have a client living in Maryland now doesn't mean that they won't move to another state at some time in the future. So you want to keep incomplete gift, non-grantor trusts in your toolbox, so to speak, because you may find a good reason to use them at some point down the road. So with that, we'll go to the next slide. So I first started thinking about these in greater detail last year after the Kastner decision came out. Kastner was a case where the Supreme Court held that in-state residents of trust beneficiaries didn't supply minimum connection with the state of North Carolina required to support that state's imposition of tax on trust income, and that North Carolina's statute as applied to that trust violated the Constitution. And just as a reminder of those facts, in Kastner, a New York resident established a trust for the benefit of his children. That trust was a wholly discretionary trust governed by New York law and had a New York resident trustee. When the grantor established a trust, nobody at the time lived in North Carolina, but the grantor's daughter moved there several years later. During the years relevant to that case, no distributions were actually made to any beneficiary. And so, it was those facts that led the court to find that the imposition of North Carolina's tax on trust income was unconstitutional. And for many of us, the facts in Kastner sound familiar. Client A and trustee B establish a trust for the benefit of child C, D, and E at a time when everybody lives in state O. And then a few years later, the child moves to state X, the trustee moves to state Y, and your client starts talking about retirement in state Z. So with grantors, beneficiaries, and trustees living in this increasingly transient world, state income tax traps are lurking, and states, as North Carolina did in Kastner, are trying to stake claim to these sources of revenue. But with the right facts and some careful planning, a trust's income tax a state income tax can be eliminated altogether. So could you advance the slide? So, as a background, let's look at some of the bases under which a state imposes income tax on a trust. So in order for a state to impose income tax on a trust, the trust has to have some minimum contact with the state. Those minimum contacts generally fall into these categories. A trust created by the will of a decedent who is domiciled in the state at death. The grantor of the trust is a current resident of the state. The trust is administered in the state. The trustee resides in the state. A beneficiary resides in the state and or receives trust distributions, or the trust earns source income in the state like rental income or business income. Next. So those are the sorts of things we're looking to avoid when we're trying to reduce or eliminate state income tax. And in the Kastner opinion, the court describes additional scenarios where minimum connection has been found and where a state law would withstand the court's review. The court has upheld a tax on trust income distributed to an in-state resident, a tax based on a trustee's in-state residence, and a tax based on the situs of trust administration. So some of the factors that we're looking to avoid when looking to avoid state income tax would be, we don't want a resident trustee. We don't want any in-state administration. We don't want a resident grantor. We are going to try to avoid trust income being distributed to an in-state resident. And there may be other state-specific factors, depending on where the client lives and where you're establishing your trust, that you would want to draft around or be aware of as you're implementing this technique. So avoiding these minimum contacts can be accomplished with an incomplete gift non-grantor trust. Next. So in a nutshell, an ING, I'm going to call it an ING for the rest of the presentation likely, an ING is a self-settled, irrevocable trust for the benefit of the grantor and other named beneficiaries. The grantor is generally a resident of a high income tax state like California, and the trust is settled in a state with low or no income tax like Nevada. The grantor ensures that the ING is a non-grantor trust for income tax purposes, so that income is not taxable to the grantor and therefore not subject to tax in the grantor's state of residence or domicile. The transfer to the ING is an incomplete gift for gift tax purposes. And finally, the ING is an asset protection trust formed in a state with favorable asset protection statutes and low or no state income tax, or at least no tax on non-residents. Next. So incorporating all of those concepts into a trust instrument requires very precise drafting, as you might imagine. You want to carefully analyze each of those characteristics to ensure that your trust instrument will achieve these outcomes. Thankfully, there are over 30 private letter rulings that approve of ING trusts. And so we have a really good roadmap for doing this. The rules are somewhat clear, though confusing and complex, as we'll talk about in a minute. But we have a blueprint for how to do this. One thing to consider is that you may decide to get a private letter ruling if you're going to implement an ING. And if you're going to do that, you want to follow these prior rulings pretty closely, because this year the service added to its list of areas in which it won't issue rulings certain incomplete gift non-grantor trusts, and those are ones that don't follow the ordinary format. So again, we know what the rules are and we can follow them. Next. And speaking of those rules, I think it'll be helpful to go through what the income tax characteristics are and what the gift tax characteristics are in a little bit greater detail, and go through the Grantor Trust Rules and the gift tax rules so that we know exactly what it is we're trying to do. So for income tax purposes, an ING is a non-grantor trust. That is a core characteristic of the ING. And if we mess that up, then we're kind of blowing up the whole thing, because you have to avoid classification as a grantor trust. Otherwise, the trust's income would be taxable to the grantor and subject to taxation in the grantor's home state. So avoiding application of the Grantor Trust Rules is critical. Next. So let's take a look at those Grantor Trust Rules. And I'm sorry, this material is very dense. For a lot of you, it's going to be review. And so I'm not going to try to harp on any of these for too long, but I do think it's important to cover. So generally, a trust is a grantor trust. And that means that the income, the grantor is then treated as the owner of the trust, and the income taxed to the grantor when one or more of these rules apply. So if the grantor has a reversionary interest, you have a grantor trust. If the beneficial enjoyment of trust income or principal is subject to a power of disposition held by the grantor or a non-adverse party, without the approval or consent of an adverse party, you have a grantor trust. Next slide. If the grantor or a non-adverse party can deal with the trust for less than full and adequate consideration, you have a grantor trust. This sounds like those Jeff Foxworthy redneck jokes as I'm saying them out loud, but the cadence is helpful for me. The next one is if the grantor or non-adverse party or both has the power to revest in the grantor title to any portion of the trust, you have a grantor trust. And finally, if income is or in the discretion of the grantor or a non-adverse party or both may be distributed to the grantor or the grantor spouse, or held or accumulated for future distribution to the grantor or the grantor spouse without the approval or consent of an adverse party, you have a grantor trust. There are, next slide. There are additional situations where a person other than the grantor can be treated as the owner. And that would be when a person has a power exercisable alone to vest the corpus or the income in himself or herself, then that person could be treated as the owner as well, and the trust taxable to them. There are also important exceptions to the Grantor Trust Rules, and they're important because they're the exceptions we're going to use to make sure we have a non-grantor trust. So first, Section 674B5 provides that Section 674A does not apply to a power to distribute corpus to or for a beneficiary, provided that the power is limited by a reasonably definite standard which is set forth in the trust instrument. The next exception is that 674B3 says that 674A does not apply to a power exercisable only by will, as long as income can't be accumulated for later distribution. And so those exceptions are going to be important because they're going to come into play when we talk about the distribution provisions. Next slide. So the way that we avoid some of these grantor trust rules is by employing a distribution committee to make distributions out of the ING. and which means that all distributions are made or directed by this distribution committee, sometimes with the consent of the grantor. And there's a couple instances where the grantor can direct distributions, and we'll talk about that too. But it's important to note that the distribution committee is controlled by adverse parties who act in a non-fiduciary capacity. So the adverse party concept is important because, as we saw when we looked at the Grantor Trust Rules, certain powers, when held with or subject to the consent of a non-adverse party, will change the tax character of your trust. So to ensure that we have a non-grantor trust, your distribution committee gets controlled by adverse parties. And let's take a look at what an adverse party is. So an adverse party is any person having a substantial beneficial interest in the trust that would be adversely affected by the exercise or non-exercise of the power he or she holds with respect to the trust. And unsurprisingly, a non-adverse party is any person who is not an adverse party. Exceedingly helpful definition there. Within the context of an ING, adverse parties are the beneficiaries to whom distributions can be made, whose interests are adverse to the interests of the grantor. The distribution committee must contain these adverse parties because, again, certain powers, critically, a power of disposition over the beneficial enjoyment of income or principal, and a power to distribute income to the grantor, when held by the grantor or a non-adverse party, will not cause the grantor trust status, so long as the power is exercisable only with the approval or consent of an adverse party. I realize that heads may be spinning because mine is starting to. But again, I promise this will all make sense once we start talking about the actual distribution provisions. So we have a distribution committee. It's made up of adverse parties. The adverse parties are beneficiaries under the trust instrument. The composition of the distribution committee can vary slightly. So, for instance, sometimes the grantor, next slide. Next slide. So sometimes the composition can vary slightly. Sometimes the grantor is a member of the distribution committee. Other times the grantor is specifically excluded, which is probably the more conservative approach. Because the distribution committee or the decision regarding who will serve on the distribution committee is driven by the class of permissible beneficiaries, a lot of consideration will likely go into who those people are. For instance, if the grantor has adult children, they are wonderful candidates to both be beneficiaries under the trust and serve on the distribution committee. If the grantor has no children, the decision becomes a little more difficult. They may be naming siblings, parents, nieces, nephews, or other individuals, knowing that if enough of them get together and decide to make a distribution, they can make a distribution. And again, those beneficiaries then form the class of potential members of the distribution committee. Also, if the grantor does have children, but they're minors, the trust instrument should permit parents or guardians of permissible beneficiaries to serve in their place on the distribution committee. So a couple of additional things to mention about the distribution committee is that the trust instrument will generally require a minimum number of members, generally 2 or 3 other than the grantor. And then the trust instrument is also going to provide that the distribution committee will cease to exist if the committee falls below that required number, and that in any event, it will cease to exist upon the grantor's death. And that kind of relates back to what I talked about earlier about co-holders of, or what I'll talk about in a minute, with respect to co-holders of powers. So those are the income tax characteristics. Next slide. The second tax characteristic of an ING are the gift tax characteristics. And the transfer, the gift tax characteristic is that the transfer is incomplete for gift tax purposes. The incomplete gift does 2 things. It first preserves the grantor's remaining exclusion amount, or prevents the payment of a gift tax if the grantor has no remaining exclusion amount. And the incomplete gift also ensures that the assets in the ing are includable in the grantor's estate and receive a step up in basis upon the grantor's death. Next slide. So it's important that we take a quick look at the gift tax rules so that we know how to prevent a completed gift. So in general, a completed gift results when the grantor gives up enough control over the transferred property so that he can no longer change its disposition, whether it's for the grantor's own benefit or for the benefit of another. Where the grantor reserves any power of disposition over the property, the gift might end up being wholly incomplete. It may be partially complete. It may be partially incomplete. We know that a gift is also incomplete if and to the extent that a reserved power gives the donor the power to name new beneficiaries or change the interests of the beneficiaries as between themselves, unless the power is a fiduciary power limited by a fixed or ascertainable standard. And again, that fiduciary component to that rule is going to come into play when we draft the agreement. So next slide. So as I mentioned earlier, there's also something to consider with respect to co-holders of powers. And here, the grantor is going to be considered to have a power if it's exercisable by him in conjunction with any person not having a substantial adverse interest in the disposition of the transferred property or the income therefrom. And here, the adverse interest is different than the adverse interest that we talked about under the Grantor Trust Rules. For gift tax purposes, our beneficiaries are not going to have a substantial adverse interest. And that's a good thing because we don't want a completed gift. We want the grantor to retain enough of a string to make the gift incomplete. So let's talk about what an adverse interest is. So a co-holder of a power does not have an adverse interest merely because of joint possession of the power, nor merely because he is a permissible appointee under a power. So here, our distribution committee, they're beneficiaries. So they hold power jointly, and they also are permissible appointees under certain powers, which we'll talk about in a minute. But a co-holder is considered to have an adverse interest where they can possess the power after the co-holder's death and can exercise it in favor of themselves. And again, that's going to come into play when we talk about certain provisions under our trust agreement. Next slide. So as all of these income and gift tax rules demonstrate, for the ing trust to work as intended, you've got to prevent a completed gift while also preventing grantor trust status. And that requires the grantor's retention of a power that will be treated as a power of disposition under the gift tax rules so that you have an incomplete gift. But you've got to curtail that power such that it's not going to be treated as a power of disposition under the Grantor Trust Rules so that you have a non-grantor trust. And the way you do that is with your drafting. So to integrate the income and gift tax characteristics of an ing, the trust instrument should set forth several distinct distribution provisions. And again, the private letter rulings that approve ings describe substantially similar terms. So we've got a really good blueprint, a really good roadmap for putting all of this together. So typically, the trust instrument requires that during the grantor's lifetime, the trustee must distribute the net income and principal of the ing to the grantor and beneficiaries as directed by the distribution committee as follows. The first way is pursuant to what is called the grantor's consent power. The second way is pursuant to the unanimous member power. Third is pursuant to the grantor's sole power. And finally, the grantor also retains a testamentary limited power of appointment. Next. So we're going to talk about each of these provisions in turn and look at how it is that they achieve the objectives of an incomplete gift and a non-grantor trust. So the first is the grantor's consent power. The grantor's consent power will provide that, pursuant to the direction of a majority of the distribution committee members, with the written consent of the grantor, the trustee shall distribute to the grantor or other beneficiaries such amounts of the net income and principal of the trust as directed by the distribution committee. Next slide. So the grantor's consent power causes the transfer of property to the ING to be wholly incomplete for gift tax purposes. Under the regulations, the distribution committee members do not have adverse interest to the grantor. Again, they're only co-holders of the distribution power, and their powers terminate upon the grantor's death, again, because the distribution committee terminates upon the grantor's death. So the grantor is then considered to have the power to distribute income and principal to any beneficiary, and the gift is incomplete. The consent power also prevents grantor trust status under Section 678 because neither the grantor nor any member of the distribution committee has the sole power to vest trust corpus or income in themselves. Next slide. The unanimous member power is the next distribution provision, and it provides that, pursuant to the direction of all distribution committee members, the trustee shall distribute to the grantor or other beneficiaries such amounts of net income or principal as directed by the distribution committee. Next slide. And as you may guess, this power also prevents grantor trust status because no one person has the ability to vest trust corpus or income in themselves. Next slide. The third power is the grantor's sole power. The grantor's sole power provides that the trustee shall distribute to any of the beneficiaries other than the grantor all or any portion of the principal of the trust directly for the health, education, maintenance, or support of the beneficiaries, again, as directed by the grantor. The grantor's sole power is only exercisable in a non-fiduciary capacity. So this power causes the transfer of property to the ING to be wholly incomplete under the regulations, even though the power is limited by an ascertainable standard, because the grantor reserved this non-fiduciary power to change the interest of the beneficiaries. This sole power also prevents grantor trust status under Section 674B5 because it is subject to a reasonably definite standard. So again, this is the perfect marriage or the perfect example of the marriage of gift tax rules and income tax rules to produce the desired result. Next slide. Next slide. Finally, the grantor's testamentary limited power of appointment is over the remainder of the trust. It's exercisable in favor of anyone other than the grantor's estate, the grantor's creditors, or the creditors of the grantor's estate. Next. The grantor's testamentary limited power of appointment causes the transfer of property to the ING to be wholly incomplete under the regulations because it's a retained power of disposition. The testamentary limited power of appointment also prevents grantor trust status under 674B3 because the power is exercisable only by will. So I was working on an ING recently where the client actually wanted to go ahead and exercise this power of appointment, and their regular estate plan is based in a trust agreement rather than a testamentary disposition. And the attorney working on the matter with me wanted to have some standalone inter vivos exercise, but I had to, advise that it really is a power that has to be exercised by will because that's what our rules say. So again, mastering these rules, knowing what they say, and constantly referring to them throughout the drafting process and throughout the implementation of your ING is really critical. So those are the distribution provisions. Again, these are not things that I've come up with. These are rules that are very clearly stated in a number of private letter rulings. The private letter rulings are substantially similar, so we have a really good roadmap for doing this. Next slide. And in addition to putting your trust agreement together, there's also some state law considerations that you should make. One of the things I opened with was there's a reason you haven't heard the acronym MING for Maryland Incomplete Gift Non-Grantor Trust. And that is because Maryland resident forming an irrevocable trust would have that trust subject to Maryland tax because of Maryland's own income tax statutes. And so Maryland residents today may not be able to do that. But if they later moved to another state, or if Maryland's law was challenged or changed, then we might have a different situation. But some other state law considerations are that your trust should be an asset protection trust. You want the asset protection because there is a regulation that says that if the grantor's spouse's creditors can reach the assets of the trust, then the grantor may be deemed the owner under the Grantor Trust Rules, and you may end up with a Grantor Trust. So ensuring that your trust is formed in a state with a pretty solid domestic asset protection statute will be critical there. The creditor protection, again, ensures that the trust is a non-grantor trust because it ensures that the grantor's creditors cannot get at the assets in the trust. Additionally, since the one of the foremost purposes of an ING is to reduce or eliminate state income tax, the grantor should also choose a jurisdiction that will not impose a tax on trust's income. There are lots of state surveys available. There are lots of resources out there that compare the various jurisdictions and what their income tax rules are. And so there's a lot at your disposal for doing that analysis and making that choice. Typically, the way that you select your jurisdiction is by appointing a trustee in that state. A lot of times people are going to use a corporate trustee. You might know an individual in the state, but basically the way you choose your jurisdiction is by appointing a trustee there. There are several jurisdictions that are known, especially as having favorable asset protection statutes and preferred tax laws. For example, Nevada and South Dakota are widely known for having a really good combination of asset protection law and low or no income tax. Ohio also has a very strong domestic asset protection trust statute that actually has a shorter statute of limitations than other jurisdictions at just 18 months. And Ohio imposes an income tax only on the income of a non-resident that is earned or received in Ohio. Other popular jurisdictions include Alaska and Wyoming, which have no income tax at all, and Delaware, which could be viewed as where this all started. And Delaware would only impose an income tax on the Delaware source income of a non-resident, as many other states would as well. And there's another consideration to make when you're looking at the asset protection component to all of this, and that is a concern that if the ING is formed in a jurisdiction whose asset protection statute permits certain exception creditors, like claims for child support or alimony, such as Delaware, that that could open the trust up to being a grantor trust because at least certain creditors could get after the trust. But there is at least one place where we know that hasn't been a problem, and that's Delaware, that does permit certain exception creditors under its domestic asset protection statute, and And there are many rulings that come out of Delaware approving of ings. So something to consider, but has not yet been shown to be a problem. Next slide. So there are some final additional considerations to make when you are thinking of doing an ing. As I've said a couple times, not everyone's going to initially benefit from this. There are also certain states that are cracking down, including New York, which has essentially said if you do a incomplete gift non-grantor trust, it's a grantor trust. And so New York residents are going to find it difficult to do, just as Maryland residents will. But something else to consider in all of this is that there have been some successful constitutional challenges to the income tax rules in certain states that try to impose tax on a trust where there's not enough contact with the state. Successful challenges have been raised in Michigan, Illinois, and Pennsylvania, and of course, most recently, North Carolina with the Kastner decision. And so just because the Maryland statute says what it says now, which is that a trust would have a resident fiduciary if the grantor is a current resident of Maryland, among a couple of other ways you get a resident trust, doesn't mean that we're going to be in this environment forever. There could be a challenge to the Maryland statute. The Maryland statute could be changed. There could be a constitutional challenge raised somewhere else that would apply here in Maryland. So again, all things to consider and why we want to keep this as a tool in our toolbox going forward. And a final consideration is that you should view this incomplete gift non-grantor trust as a rainy day fund, because many of the benefits of the trust are going to be lost if and when distributions are made. So for instance, any income or principal distributed from the ing to the grantor will be subject to taxation, likely in the grantor's state of domicile or residence, depending on what the statute says. Additionally, any assets that are distributed to other beneficiaries are going to be regarded as being completed gifts for gift tax purposes. And those assets would also be subject to income tax in the beneficiary's state of domicile. So the client has to be prepared to fund their ing trust and then kind of leave it alone for so long as they know, or for so long as they don't need them for some other reason. Next slide. And I think that is the last one, which is, okay, next slide. So again, just to kind of summarize everything, and thankfully we've got some time for questions, if there are any. The ings can be a really powerful tool for achieving estate planning goals, and namely reducing or eliminating state income tax. You have to be very careful about drafting your trust agreement and selecting your beneficiaries, because your distribution powers are going to ensure that the trust is a non-grantor trust, and that the grantor's transfer to the trust is an incomplete gift. You also want to be deliberate when you select your jurisdiction, and you have to weigh various factors, including asset protection and income tax rules. And finally, as I just touched on, you want to view an ing as being a rainy day fund, and it shouldn't be viewed as being a current resource to the grantor, because again, those benefits are going to be lost when distributions are made. So with that, I can hand it back over to Ricky. If there are questions, I'm happy to take them. I'm glad I didn't use the full hour because I'm sure everyone's busy, but I was glad to be here today. And thank you.
Thank you, Lindsay. And so far, it looks like there's two questions.
Okay.
So I'll read them out to you.
Okay.
First one is, how would you address arguments asserting that members of the Ing Trust Distribution Committee are fiduciaries because of the distributive nature of their powers of appointment?
Okay. Should I take that one first?
Sure. Do you want me to say? I can say the second one too. It might kind of relate to it.
Okay.
It's to clarify, even if explicitly labeled as non-fiduciary, how can a distribution power be considered anything but fiduciary in nature when exercisable in favor of beneficiaries?
Okay. Um, those are really good questions, and certainly ones that I consider when working through these issues. As to whether or not the distribution committee is acting as a fiduciary, um, there are a lot of other situations where people have powers under instruments, like under directed trusts. We know that those people or a trust director would be a fiduciary. So how is a distribution committee not? Um, and I unfortunately don't have a great answer for that. I'm sure that that would be the argument, but again, because we know that our trust instrument is going to say that they're not acting in a fiduciary role, and they owe no duties to anyone. I mean, I think that's how you get at, do you have a fiduciary or not, or are you open to liability? And there's no duty imposed on any of the distribution committee members. Um, and so I think that's how you would address that, to say, look, this is just a power to directed distribution. There's no it's like that's wholly discretionary. There's no duties owed to any of the other members or beneficiaries or grantor, and therefore it's not a fiduciary power, which again is something that is highlighted and permissible under the income and state and gift tax rules.
Great. And those are the only two questions that I see posted.
Okay. Well, if anybody has anything further, or to the extent
Oh,
that,
but actually, it looks like there's one more, Lindsay. Sorry. Why are INGs so helpful if the benefits are lost when distributions are made?
right, yeah. Well, they're very helpful in terms well, for a variety of reasons. One of which, again, is just that income tax savings. So, there have been some calculations and analysis done to show the overall growth that can be achieved when you're saving that 8 or 10, or in some cases 13%. By not having to pay state income tax each year, and the accelerated rate at which the trust can grow because it's not subject to that state tax, or excuse me, the state income tax. There are other situations where these could be incredibly helpful, especially in the family business context. If you have maybe one or more generations of a family who own interest in the same business, and one of those people maybe lives in a high income tax state like California, they can contribute that interest to an incomplete gift non-grantor trust in advance of the sale. You'd want to do it in as much advance as possible so that it's not viewed as being somehow abusive. And that way, when the business is sold, the interest held in that trust is not then subject to an additional state income tax being tacked on to that transaction. So the benefits are that you're not being subject to state income tax, and that it can be a tremendous savings. And then ultimately, if the assets are held for future distribution to beneficiaries, then at the end of the trust, when they're distributed, they will have grown, appreciated, and been given a step up in basis when the grantor dies. There's also now added benefits to non-grantor trusts after the Tax Cuts and Jobs Act, which are that non-grantor trusts get additional SALT deductions, and can also get charitable deductions under 642C. And again, you'd have to marry all of that together, and that goes beyond, some of that goes beyond the scope of this presentation. But there are a lot of benefits, even though distributions shouldn't be made to the extent possible.
Excellent. There's one more question now.
Okay.
I have not drafted trust before. What is a reversionary interest with respect to grantor's interest in income/principal?
Okay, so a reversionary interest, like the one described under the Grantor Trust Rules, is an interest that can come back to the grantor. And it's unfortunately not a super basic concept for anybody who's kind of just starting out in this field. But essentially, it is if I make a gift to a trust and there's a possibility of a reversion in that interest to me, that at the time I set the trust up exceeds 5% of the value, then that trust will be a grantor trust with respect to me. Again, not a super that's not a basic concept, but that is what that means. Anything else?
I think that might be it. These were great questions, everybody. Thank
Hey,
you.
yeah, agreed. And thank you everybody for watching. Thank you again to Ricky and Micah. And I guess we'll turn it back over, or I'm going to turn it back over to Ricky and Micah and Anna.
Thanks, everyone. Thanks, Lindsay. This was a great presentation. We will, and we have recorded this, so this will be up for viewing later if you want to reference it back to it. But thank you, everybody, and have a great day.
Thank you, everybody. Stay